So, what's the real difference between just doing your job and actually committing a crime? It sounds like a simple question, right? Well, today we're diving into a landmark Supreme Court case that drew a billion-dollar line in the sand to answer that very question.
I mean, think about it. Can you be a racketeer just by doing your job? It sounds pretty wild, doesn't it? But for decades, this was a massive, unanswered legal puzzle. Could professionals, people like accountants or lawyers, get dragged into a huge fraud lawsuit just for providing their normal, everyday services? That's the core tension we're going to unpack.
All right, to really get to the heart of this, we first need to understand the law at the center of the storm. And it's a really powerful legal weapon known as the Civil RICO Act. Now, you've probably heard of RICO. It was originally designed to fight organized crime. We're talking mob bosses. But its civil version, wow, it gives private citizens an incredible tool. If you've been harmed by an organization's pattern of illegal activity, you can sue them for, get this, triple damages. So yeah, it's a super high-stakes law, which is exactly why this case became such a big deal. So let's see how this law got put to the test in the real world. Our story kicks off with a total financial collapse of a farmers' cooperative down in Arkansas. So here's the setup. You've got this local co-op, and it's selling investment notes to its members. These are basically IOUs that pay interest. But here's the thing. Behind the scenes, the co-op was bleeding money. They hired a big-time accounting firm, Ernst Young, to do their audits. And then, bam, in 1984, the whole thing just fell apart. The co-op went bankrupt, and its investors, these are everyday farmers, they lost everything. And this is where things get really interesting. The investors, who were furious, didn't just sue the bankrupt co-op. Nope, they went after the deep pockets, the accounting firm. And in doing so, they raised this huge legal question about who exactly could be held responsible. They used that powerful Civil RICO Act we just talked about, and their argument was this. The accounting firm wasn't just some neutral outsider. They claimed the firm actively participated in the co-op's fraud by creating audit reports that made this failing company look financially healthy. And that, they said, allowed the co-op to keep selling more and more worthless notes. The entire case, everything, hinged on this one single word, participation. The RICO law says you have to participate in an organization's illegal activities to be liable. But, and this is a big but, the law never actually defined what participation really meant. And that was the multi-billion-dollar question. I mean, is creating a faulty audit report participation? Does just giving legal advice count? Lower courts were all over the map on this, creating a total mess of conflicting rulings. Some courts said, yeah, just helping out is enough. Others said, no way, you have to be directly involved in the fraud. The entire business world needed some clarity, and that's when the Supreme Court finally stepped in. And this brings us to the climax of our story. In 1993, in a case called Reves v. Ernst Young, the Supreme Court finally laid down the law and gave everyone a clear, definitive standard. And here it is. This is the sentence that changed everything. The court said it wasn't enough to just be involved. To be on the hook under RICO, you have to participate in the operation or management of the organization itself. You've got to have some hand on the steering wheel, so to speak. This created what we now call the Reves test, or the operation or management test. And what it does is draw a really bright line. It asks a pretty simple question. Are you just an outside advisor providing a service, or are you actually helping to direct the company's decisions? You know, the best way to think about it is this captain of the ship analogy. It just makes it all click. Think of a company as a ship. The people who are liable under RICO are the ones directing it, the captain, the officers, the ones actually steering the course. The accountant or the lawyer, well, they're like the person who provides the navigational charts. They are absolutely essential for sure, but they aren't the ones running the ship. So you might be thinking, okay, why are we still talking about a case from 1993? Well, because its legacy is massive. The Reves test completely reshaped the entire landscape of corporate accountability and the risks that outside professionals face every single day. Just think about the impact for a second. Before this case, the legal risk for an accounting firm or a law firm was huge and, frankly, totally unpredictable. But after Reves, there was clarity. As long as you were just providing your professional services and not crossing that line into directing the company, you were protected from these incredibly powerful RICO lawsuits. So to wrap this all up, what should you really take away from this? Well, the Reves case gave us a clear legal standard. It protects outside advisors from being unfairly targeted. And it defines that absolutely crucial boundary between just providing a service and actually helping to run the show.
And that leaves us with one last fascinating question to think about. The operation or management test. It definitely provides some really important protections, but does it also create a blind spot? Could it maybe allow a clever advisor to knowingly help a corrupt company cause a ton of harm as long as they're super careful to avoid stepping into a management role? That's a debate that is still going on today.